Hey everybody, Paul Rabelais here, and welcome to Estate Planning Live on YouTube. So I'm Paul Rabelais, I'm your host. A little background on me: been an estate planning attorney for 31 years. Had a YouTube presence on here on YouTube for about the last 6 years. Pretty sure it's the largest estate planning oriented channel on YouTube. So got a lot to cover. First, let me go over a little bit of the rules on our show, Estate Planning Live. One, make sure you do subscribe to post your comments and questions in the chat. We have as you may see in your chat, it's turned on where only channel subscribers can send messages. Periodically, during the YouTube Live, I'm going to take a look at the chat and I'm going to address many of the questions and comments that are posed. That's the beauty of YouTube Live is you may have a question and you can pose it right here while we're live, and all works out well. I get to it and able to have that interaction, which I really like. Keep your comments and your chat clean and positive. We'll go about 30 minutes, sometimes a tad bit longer, depending upon the questions that are posed in the chat. Your questions posed in the chat create the content for my future YouTube Estate Planning Live presentations. So the idea, every Monday through Friday, 4 o'clock Central. In fact, you may want to, in the morning or so, check out my YouTube channel's community tab each morning. One, to confirm that I'll be giving an estate planning live presentation at 4 o'clock Central that day, and to see what the main topic of that presentation will be for the upcoming estate planning live. Donna, first one to chat in. Hello from Louisiana. I'm your neighbor, and hope things are well in Texas. Okay. Today's topic is talking all about how to take care of your spouse in estate planning. One of the most important things you can do. You and your spouse may have worked for many, many years, tried to scrimp and save and build up things and buy a house and accumulate some investments. And so what I want to cover today is what are those things that spouses should be doing to make things easy for each other. You can make things really difficult and you can make things easy. Hey, Patty from Buffalo, New York. All right, so providing for your spouse in estate planning is important because if you don't, then, sounds cliche, bad things can happen. Some of those bad things that can and do happen when married couples don't provide for each other on the estate plan, not even talking about when one passes away, but when one becomes incapacitated. Hey, Nick's from Delaware. I mean, we got many states going on here. Fantastic. Keep them coming. When you don't have that estate plan, and when one spouse gets to a point where they're not able to sign their name, deal with their financial accounts, talk to their doctors, whether that's illness or injury, then if you don't have the estate planning components that I'll be talking about here in a minute, it's very possible that your spouse may have to sue you in a court proceeding, have a judge declare you incompetent, and have a judge appoint you or someone else as your spouse's legal guardian. So, for example, if your house has to be sold and your spouse, whose name is on the title, is not able to sign to transact that sale of the house, then the well spouse is likely going to have to sue the not well spouse in those guardianship or conservatorship proceedings. So that's a couple of the things that can happen. Also, when couples don't take care of each other, when there's that first death, there could be lots of problems. Assets could be left pursuant to the state laws, which may make things difficult for the surviving spouse. The surviving spouse may have to get permission from other heirs to sell the house or transact certain assets. With no planning in place, that surviving spouse is going to have to go through a difficult, lengthy, expensive court proceeding called probate, where assets in your name when you pass away are frozen, and there's no way to get them unfrozen without going through that court and attorney involved probate. So we'll be talking through some of the ways that you can eliminate all that for your spouse. Hey, Doug from North Carolina, great to have you here. All right, so let's start with kind of take it chronologically. What are the things that a married person can do to take care of their spouse? Really the same thing, even if you have an unmarried life partner, these same rules apply. In fact, I think the problems even escalate, because if you have an unmarried kind of life partner, they're not going to inherit from you one bit. if you have no planning in place. So the problems are even bigger in the kind of unmarried life partner situation. But I'll just refer to that whole scenario as leaving things to your spouse. We got Washington in the house. Good to see you, Irina. All right. So one of the first things you'll want to do is you'll want to make sure all that if I'm incapacitated stuff, how do I make things easy for my spouse? Let's get all that straight. So what you'll do is you'll create these in many states called powers of attorney or financial powers of attorney or general power of attorney or general durable power of attorney. All of that is where you're making it easy for your spouse, if your spouse is the one who you'd want handling things for you. In that general durable power of attorney or any of those names that I just mentioned, you get to dictate, if I'm incapacitated, who do I want handling all of my money and all of my business transactions for me? Again, if you don't have that in place and you become incapacitated, people have to sue you, take you to court. It's just a mess. I've been involved in so many of those, and I regret every one of them. Or wish they would have never happened, because I wish the people would have planned better. But the idea here is set up these powers of attorney so that if you do in the future, through illness or injury, get to a point where you can't handle things for yourself, you've got the people lined up right in a row who you'd want to be able to and trust to be able to handle your money, and they can do it with ease. Most people on their power of attorney, if they're married, they name their spouse as their first agent. And then if they have perhaps adult children or other trusted friends or relatives, those people will serve as the backup to the spouse. So you want to make sure you get that done. On the medical side, there's a number of things you could do to make things easier for your spouse. Some states call it a healthcare power of attorney. Some states call it an advanced healthcare directive, healthcare proxy. We have all these different names, but in general, they all mean the same thing. It's, if I'm not able to make medical decisions for myself, who do I want being able to talk to the doctors, make treatment decisions for me? We'll get to the life support stuff here in a minute, but this is just, I might be in surgery, or I might have Alzheimer's, or for some reason, I'm not on life support. I just can't make my own medical decisions. So again, with that healthcare legal document, you can direct who you'd want having that ability to talk to doctors, get your medical records, deal with insurance companies, document all that on that healthcare power of attorney, on that advanced healthcare directive, and you'll be making things much easier for your spouse. Again, typically you'll name your spouse as your primary agent, maybe another adult child or children as your alternate or backup agents. And then there's the whole living will aspect, that statement regarding life support machines. I've been at it from the other side, where people sat across the table from me, maybe a surviving wife after she just lost her husband. And she's telling me the story about how her husband was in the hospital and she had to make the difficult decision to terminate her husband's life because he was on life support and she didn't know what to do. And so that's what she did. And again, it's just really difficult, where that husband could have signed a living will, taken all of that burden and grief off of his wife by signing a living will and documenting his wishes regarding the withholding and withdrawal of life support machines when he gets to that point where he's in that profound vegetative state with no chance of recovery. So that living will is where you do direct your family and physicians to honor your wishes regarding the withholding or withdrawal of life support if you're in that vegetative state with no chance of recovery. Appreciate you agreeing with me. Creamy S. Brianna, quite the name there. Yes, POA for health and advanced healthcare directive are important. Good to see that. Feel free to share a story or two if you have that. So all that, if I'm alive and I can't make those decisions for myself, all that stuff is really important. Most people think estate planning is all about what happens when I pass away. But it also, with people living longer, medicine doing what medicine does, keeping people alive longer. More people now are living for months or years in a condition where they can't make decisions for themselves. And so these incapacity, planning, as we call it, really is important. It's your spouse is going to have enough to go through physically and mentally. Don't create all these legal burdens for them. Make sure you take care of the incapacity planning. All right, let's see here. Patty, my parents never made wills. My father died without a will, and all property passed to my mother. No probate. Low estate value. I made sure my mother had a will after my father died. So maybe that low, I hired a top elder law estate attorney. Good for you, Patty. So maybe that low estate value in your state may have allowed some things to go outside of probate to that surviving spouse, or maybe the way some things were titled. Many states permit things to be titled, husband and wife joint tenants as rights of survivorship. So when one spouse dies, things automatically go to that surviving spouse. So good to see that you had a good story there. Okay. Next, I want to cover really the beef of what I'm here for today, of how to take care of your spouse. It's that when the first spouse dies, how do you make things easy for the surviving spouse? Yes, the surviving spouse is likely to be going through some grief, or maybe they'll be celebrating. I don't know. But nonetheless, there's going to be some legal burdens put on that surviving spouse that can be alleviated by taking a few easy actions during your lifetime. Really, what I'd like to focus on is an often overlooked decision that married couples have. Exactly, Patty. Good. I'm glad I got that right. I made some guesses and looks like I was right. So an often overlooked decision that married couples have is when the first spouse dies, how do you leave stuff to the surviving spouse? On tomorrow's Estate Planning Live, tomorrow will be May 4th. If you're watching this on a video and want to look up the video, I'm going to focus on the many different options that either individuals or couples have on how to leave it to the children or the heirs. Today is all about how to leave it to your spouse. And I want to go through some key distinctions. There's not a right or wrong way to do it, but I want to give you the ways to do it and the pros and cons of each. I'm going to start with a simple one. The first option that couples have on how to leave things to each other is where they leave everything, what I call outright, to the surviving spouse. That's pretty easy to understand. Husband has a will or a living trust. We'll get into all that in a minute. But essentially, he says, if I pass away before my spouse or before my wife, whatever I have, it's all hers. And maybe the wife does the same thing. If I die first, it's all his. That's pretty easy to understand. Maybe they have an estate worth $2 million. It could be $200,000. It could be $20 million. But let's say it's $2 million. And let's say each one owns $1 million. Husband dies. He has $1 million. He leaves this to his wife. So now she owns the entire $2 million. That's pretty simple to understand. And in fact, that's probably the simplest scenario for the surviving spouse. So it's so simple, though, that there's some disadvantage. There's some potential disadvantages. So if the first spouse to die just leaves everything that they own to their surviving spouse, easy enough for the surviving spouse. The surviving spouse is in complete control of everything. However, the surviving spouse could, in theory, in theory, you know what? I like to be blunt about stuff because I'm not looking into that couple's eyes and talking about remarriage and that kind of thing. But that's the beauty of YouTube Live. I can say whatever I want. I'm not looking into people's eyes and saying, I wouldn't do that or my spouse wouldn't do that. But when the first spouse to die leaves their things outright to the surviving spouse could remarry and leave what was the first spouse to die's estate to the surviving spouse's next spouse. Or we see it a lot, people living longer, the surviving spouse could get influenced by some bad person, sign something that they really did not intend to sign, and again, either give away or leave assets to people that the first spouse to die would not have wanted. So outright to spouse, easy to understand, simple for the surviving spouse, but there's a chance that those assets could wind up in unintended hands. All right, so I hope you can understand that. Patty says, thankfully, my husband and I are on the same page estate-wise, lots of intricacies to address. Maybe that's what we're doing on these daily YouTube Live presentation, is dealing with intricacies. Speaking of intricacies, that's a hard word to say 5 times fast. Now that we've covered outright to spouse, easy for spouse, so almost too easy for the surviving spouse to give it away to other people. The next option that I want to pose for married couples, very, very common, is instead of, let's go back to that example with married couple has $2 million of assets, which may include a home, may include investments, may include money in the bank, may include vehicles. But let's say each spouse owns one half, or each spouse owns $1 million. outright to spouse. Husband dies, leaves his $1 million to the wife. She has $2 million, and she might redirect it to other places when she dies later. Second option is, but I will tell you from a maybe a capital gains tax perspective, that might be the best scenario, because at least in community property states, or really in any state, when the husband dies, if it's a community property state, all of the community property gets a step up in basis, which is a good thing. And if it's not a community property state, when the husband dies, his assets will get a step up in basis. And then he leaves it all to his wife. And then let's say she lives another 5 or 10 years, and those assets, appreciate in value from the time the husband died until the wife died. Since he left everything to her, all those assets will get another step up in basis when the surviving spouse dies. That saves everybody capital gains tax. Step up in basis is a good thing. A step up in basis will be another subject of a YouTube Live dealing with more intricacies. All right. VC said, thank you for doing this. We are old and have, you probably meant waited, but you put water too long. Vicky in California. Thank you, Vicky. How old is old? Because sometimes I think I'm old. So anyway, and good point, Erica, need trust, otherwise probate. Excellent timing on that point, because all of these things that we're talking about doing for your spouse, leaving things outright, leaving things in trust, which in trust is what I'm going to get into heavy here in a minute. You can do all of that two different ways. You can leave all of what you have either through your will, where you leave everything in your name, and when you die, whoever you leave it to, all of that's part of your will. But when you leave it to others, including your spouse, through your will, then when you die, because assets are in your name, your surviving spouse and anybody else who stands to inherit from you will go through an attorney and court-involved probate proceeding. So leaving it to your spouse in a will is really easy for you. You leave everything in your name. You make sure your will is done right. But the downside is when you pass away, your survivors have to go through that court proceeding. So what many, many, many people do is they arrange all of this. They set up their living trust while they're alive. They retitle their home and other assets into their trust. Things in a trust don't have to go through that court and attorney-involved probate process when you pass away. You just designate a successor trustee. You're the original trustee. You set up a successor trustee, might be your spouse, might be somebody else, who can transfer those assets out of your trust when you pass away without having to go through the attorney and court-involved process. Wow, only 70. You got a solid 20, 30 years to go. I'd say you're middle-aged. Okay, so now we're going to talk about, here's the beef. Now we're going to talk about how married couples can leave things in trust for each other. So this is the deal, $2 million, each has $1 million. The husband's sitting there saying, do I leave everything to my wife? She sure is pretty, and she might get remarried to some hot guy, and she might leave my estate to him. Probably shouldn't say that, but I did. And maybe he's thinking, you know what? We have kids together, or maybe he's saying, I have kids. I want to provide for my wife, and I want to make everything that I have available for my wife because she might need it. I don't know how she might live another 20 or 30 years. She's going to need resources to live off of. But the husband's thinking, when she dies, if there's anything left in my estate that she didn't spend or use, I want to make sure that the remaining part of my estate that she didn't use, I want to make sure that that goes back to my beneficiaries. So that's really the number one reason spouses leave things in trust for their spouse. It's available to their spouse. It can be used for their spouse's needs. But when the spouse later dies, those assets revert back to the heirs or beneficiaries of the first spouse to die. When you leave things in a trust, we did a TOD, transfer on death, for our home. That makes things, homes pass outside of probate. Does this apply to Canada? Colleen, welcome back. You were our questioner of the day yesterday. Again, wish I could be all things to all people in the universe, but I'm not your Canada person. Carolyn, my spouse made a will. The lawyer told him how to do it, gave half to wife and half to kids. This is not fair. Okay. Well, good point. So, not sure how to comment there, kind of speechless on that one. But thanks for sharing. All right. When you leave things in trust, you have a number of decisions to make when you leave things in trust for your spouse. Husband says, I've got $1 million. Wife's got $1 million. I'm leaving my $1 million in a trust for my wife. Decision number one, who's going to be the trustee of that trust? Typically, it's the wife who would be the trustee. I leave my $1 million in trust for my wife. She can be the trustee. So she manages that $1 million of assets that I left in trust for her. She still has her own million, but now she's the trustee of a trust that holds my $1 million. So you might name your spouse as the trustee. You might name your spouse as a co-trustee with someone else. So that gives a little more checks and balances. You might, we don't see this often. I think we're going to see it a lot more in the future, where spouses will name a corporate trust department as the costs of using a corporate trustee decrease because technological advances are improving. We're going to see that because individuals, the typical individual doesn't know how to be a trustee. They don't know what the trustee duties are. They don't know what the trustee responsibilities are. I was having a conversation with a trust company executive today, and so we're excited to see some of the things that are happening in the world of corporate trust companies. But nonetheless, that one of those decisions that you'll make when you leave things to your spouse is who will be that trustee of that trust after you pass away for the benefit of your spouse. Then a couple of other decisions. If you leave things in trust for your spouse, what we're going to be talking about next is income beneficiaries and access to principal. So let's say you've got a husband's got $1 million. He leaves it in trust for his spouse. He names his wife as the trustee of that trust. What he's going to say is his wife is the income beneficiary of that trust. And we're going to talk about how long that will last in a minute. So what does it mean to be the income beneficiary of a trust? Husband died, $1 million left in trust for his wife. Wife is the income beneficiary. So income beneficiary means she's entitled to the income that the trust assets produce. Maybe the trust assets produce some interest because the trust assets, CDs and savings accounts were part of the trust assets. Maybe the trust assets produced some dividends because stock was held in that trust. So the income beneficiary is entitled to that income that's generated, which is different than capital appreciation. So maybe if it's $1 million trust and it produces between interest and dividends, maybe 1% income return, that $10,000 of income each year would just go to the surviving wife. That would be hers. We want it to be that way because we want that income distributed to her so she can report that on her personal income tax return rather than have it accumulated in the trust and have the trust file a tax return and pay higher trust income tax rates. But the real reason we want the wife to be the income beneficiary of that trust is we want her to be the in trust for the rest of her lifetime. So we want that trust to qualify. Here goes the legal lingo. We want that to be a Q-tip trust, qualified terminable interest property trust. The idea is if by chance when husband died, his estate was larger than the estate tax exemption, $12 million now, coming back to maybe $6.5 million in 2026. If he left, and let's say he had a $10 million estate, well, in 2026, that's going to be much larger than the $6.5 million exemption. So you think, wow, there'd be a whopping sum of 40% estate tax due on the excess over $6.5 million. But because he left it to a trust that provided that his wife would get the income for the rest of her lifetime, then no estate taxes due when the husband died. That excess over the $6.5 million, assuming he dies in 2026, no 40% estate tax due on that. It would just become part of the wife's estate to be taxed when she dies. But to get that favorable estate tax deferral or estate tax avoidance treatment, the trust he leaves for his wife has to provide that she gets the income. The IRS wants to make sure that those assets are there when the surviving wife dies because they can be subject to the estate tax then. So we always want typically want, we absolutely want, if there's the potential for the first spouse to die, to have an estate that's larger than the estate tax exemption. We absolutely want that spouse, that trust left for the spouse. We want that spouse to be able to get the income for life. Okay, now the second question is, now, how can that surviving spouse use the principal of the trust? So the income is that $10,000 of income that the $1 million trust produce. The principal is the $1 million. Can the surviving spouse use that? It depends on how you set it up. So let me go here, and I'm going to come back to that because this is an important concept. Except when the trustee gets dementia. Okay, thank you for this series. Did a trust about 20 years ago, but it is past time for a review update, especially with all the changes in the law. Kept putting it off because plan to move from California back home to Texas with family. Okay, I've got maybe a solution for you there, Jane. I am the one who bought the house and paid for everything. Okay, now we're talking. Now I see why you made your previous comment, Carolyn. Can corporate trustees be rather rigid with one's ability to access and move funds? Maybe depends on what the trust permits that corporate trustee to do. All right, so I'm going to come back to that in a minute. Hubby and I are like Patty W. and Hubby Trust estate-wise. Good buffering. If you leave your estate to your spouse in their own trust, what stops the surviving spouse from emptying the trust and giving the balance to a second spouse, leaving nothing for the children? Well, maybe don't have that surviving spouse as the sole trustee of that trust. That could prevent them from violating trustee duties. And maybe the surviving spouse is prohibited based on the terms of the trust instrument from giving those assets to someone else. Now, maybe the surviving spouse could, because they have their hands in the cookie jar, they can steal from the trust, but that would be very inappropriate. So, but probably a non-spouse trustee is your answer there. So, all right, let's go back to husband died, $1 million trust, left it in trust for a spouse, maybe named his spouse as a trustee. I don't think our heart would do that. He might name spouse as a co-trustee or might name another trustee altogether. Spouse gets income for life. That's great estate tax treatment. How much principal is that spouse entitled to? I will tell you all of these options that I'm about to give you. I've been an attorney in my state for 31 years here. About 2 years ago, when COVID started, I co-founded a company with two other gentlemen. It's called myadvocate.com, and it's designed for people in all 58 states to be able to build their estate plan online, self-directed. All these options that I'm about to give you, you can do all of that in myadvocate.com. In fact, you can build it for free and see what it looks like and not have to incur any expense until you go to print the documents, but that's another story. So, here's I'm leaving my estate in trust for my spouse. What principal distributions do I want to make available to my spouse? Some people, not many, will say, I just want my spouse to get the income and the income only. I don't want them to get any principal distribution. So they get that roughly $10,000 of income per year. And I pulled that number out of thin air. Sometimes people say, I want my spouse to be able to take principal distributions. They'll get the income for the rest of their lifetime, but I only want them to be able to get principal distributions until they either die or remarry, whichever happens first. Once they remarry, they're not going to get any principal distributions, or then they're not entitled to any principal distributions from that trust. I want the principal distributions to my spouse to stop when my surviving spouse remarries. But I'd say probably the most common is husband dies. He leaves his estate in trust for his spouse. She gets that income for life because that's favorable estate tax treatment. And he says that the trustee is permitted to make principal distributions to the spouse for the spouse's health, education, maintenance, and support, the typical HIM standard. And the spouse can get those principal distributions for the rest of the spouse's lifetime. Okay, so you should be starting to see that it's not just as simple as, do I leave it all to my spouse outright, or do I leave it in trust? In this discussion, we've talked about estate tax consequences, which don't affect everyone. They tend to affect the higher net worth people. We've talked about capital gains tax consequences, which do affect pretty much everyone. And so all that goes into that decision of how you leave your estate to your spouse. And then you could have a combination. Some people say, yep, my spouse and I own a house together. And if I pass away first, I want to leave my part of the house outright to my spouse. She can have it. She can sell it. She can do whatever she wants to with it. It's hers. We work together to pay that house off. If I pass away first, I want my surviving spouse to own our home. But as to the rest of my estate, my portion of the investments, my portion of a business that we own, of rental property, as to the rest of my estate, I want that to go into a trust. Maybe my spouse will be the trustee. Maybe my spouse will be a co-trustee. Maybe someone else will be the trustee. I want my spouse to get the income off of that for the rest of my spouse's lifetime. But when my spouse dies, I want to make sure that those trust assets revert back to my beneficiaries, my children, my heirs, my children, my grandchildren, whoever it was I designated when I set all of this up. All right, looks like we're having some problems with the technology. Distorted video okay here. Good, Patty. Yes, in Chicago, Deborah's hearing things. No sound. No problems with audio in California from Jane. So we'll see when the recording of this comes out tomorrow with all the chat after YouTube processes it. We'll see if the video is loud and clear. Irina, thank you for your all good comment. Hey, Mitch from New York, and good to hear Donna's coming in loud and clear. Okay, so we've talked about when you pass away, outright to your spouse and trust for your spouse. A couple of other decisions. Number one, you want to make sure if you're trying to make things easy for your spouse, in your will, you'll name an executor. Probably should be your spouse. I shouldn't say probably should be your spouse, but it's most common for married couples when they write a will to name their spouse as their executor. It's common when married couples create a joint living trust that both spouses are the co-trustees of that trust when it's set up. And then the surviving spouse is the sole trustee of that trust after one spouse dies. So those are other things that you'll want to address as well. Now, a few other miscellaneous items here that I want to address for married couples. One, if you're the one who kind of handles the money, and we all know, or typically in a married couple, there's one spouse who kind of opens all the statements and deals with all the bank accounts and the investment accounts. And so it's real important that you organize all of that asset information. What we don't want, and what we've seen a number of times, at least I have, is one spouse dies and that surviving spouse is like, I don't know what we have. And so it delays the settling everything by months and sometimes years, because we can't finish settling everything until we know exactly all of the assets that are titled in the name of the first spouse to die. So make sure it could be as simple as making a handwritten list of everything you own, and it can go, far more than that, to having it organized in binders, to using an online tool to document what you have. And then there's the whole estate tax scenario for wealthier couples. With the estate tax, the federal estate tax provisions like they are, regardless of the size of a married couple's estate, it can be set up so that when the first spouse dies, 0 of this 40% estate tax has to be paid. Between things like the marital deduction, where you can leave things to your spouse and it's not included in the first spouse to die's gross estate, to the leaving things in trust for your spouse to get the income for life, qualifies for this Q-tip election, to something called a portability election that's made when the first spouse dies to increase the surviving spouse's estate tax exemption amount. All of these things that will be addressed on future YouTube Live. You want to make sure that's part of the let me take care of my spouse part of the estate plan. A couple of other items, then I'm going to hit the chat, and then we're going to wrap up here. It may be best, even though you leave your estate in trust for your spouse, it may be best. I talked about a combination of leaving some things outright to your spouse. Maybe you want to leave all the personal items, all the vehicles, all the stuff outright to your spouse so they can do whatever they want to with it without having to worry about being accountable to the heirs down the road. So sometimes there's some things that practical sense to leave outright to your spouse. And then don't go through this alone as a spouse. You want to make sure your spouse does the same thing for you. So it's extremely common for married couples to go through this together and make those joint decisions. All right, back to the chat here for, let's see here. Enjoying terms loud and clear. Good. Sounds like some people had some technology issues, but Christine, good to hear things are good. Being a trustee can be a pain in the, I would never want to be one. Patty, I don't blame you. Particularly if you don't have an excellent relationship with the beneficiaries of that trust. Your job as a trustee, particularly if the beneficiaries, don't fully trust you and support everything that you're doing, your job as a trustee, I can virtually guarantee you, will be a nightmare. Number one, you don't know how to be a trustee. You don't know all the accounting rules, the investment rules, the trustee duties. So we're going to see a world coming up here, and we're in 2022, but in the late 2020s and 2030s, I think we're just going to see a lot more trusts being created and a lot more corporate trust environment because families are getting more complicated, and trusts are simply the solution to a lot of these kind of what used to be unusual, now common family situations. All right, let's see here. Is there a difference between going through lawyer or doing it yourself when it comes to someone contesting it? That's a really good question, Nix Escobar. So when estate or estate documents are contested, the reasons that I would say the most common reasons they are contested are, number one, whoever created the estate plan, it's alleged that they did not meet the validity requirements. Maybe there was something that should have been notarized that wasn't. So whether you do it online and you get the good instruction to make sure you follow those validity requirements, or whether you go through an attorney, I don't know that one's better than the other. Number two reason things get contested from an estate standpoint is people often allege that the person who signed the documents didn't have the capacity to understand what they were doing. Or maybe it's alleged that the person who signed the documents was adversely influenced by someone. So that's a strong argument for take care of this stuff while your mind is good, while your capacity is good, while you have the ability to really understand what you're doing. And so I don't think it really matters whether you do it online or an attorney to satisfy that. And then the other reason these things get challenged is because perhaps language used in the documents was ambiguous and different parties interpret documents different. So again, the same thing, if that's as the legal team leader for my advocate, that's on me on this online platform called myadvocate.com to make sure that when you answer the questions, the actual documents reflect and are clear exactly what you want. Same thing with an attorney. That's an attorney's job to take what you want and draft it in a way that it's not subject to different interpretations. So it's just, what you're most comfortable with. Some people are kind of traditional and comfortable with the old system of attorneys, face-to-face meetings, drafts, reviews. And then other people are now becoming comfortable with the online platform, particularly with all of the education that our My Advocate company provides as part of the estate planning building process. What about leaving my spouse for my, Not Real says, what about leaving my spouse for my estate? Not Real, that's not understandable. And that's a joke. I was going to say not a joke, but I don't understand what you're asking. Creamy, yes, get an estate plan long before your health deteriorates. It becomes a huge pain when there are no plans in place. Good point. In my 40s and have an estate plan with my partner. Excellent there. Creamy, yes. Brianna, if I'm saying that way. Anthony says, I have a beneficiary deed that states the title goes to me after my parents pass on. Is that all I will need to sell the house? Beneficiary deed, that's really a state specific issue. It may be appropriate in your state and may not be. It's a state specific issue. And not only do you live in a state where that's permitted, but is the or the things that you have done correctly and valid and all that. So tough question to answer there. Okay, so we're going to wrap it up here. So again, thanks everybody for participating. Love doing the YouTube live. I'm going to keep making my videos on the side and then uploading them to YouTube, but I'm also going to do my estate planning live presentations where you can join me. Go ahead and just tell everybody, we'll be doing this at 4 o'clock every day, Monday through Friday, 4 o'clock Central. And you can check in the morning because the evening before, I'm going to post on my YouTube channel's community tab the fact I'm going to confirm that I'm going to be doing it that day at 4, and I'm going to be telling you the subject matter of that day's comment or that day's presentation. In the chat, in the comments to these videos, once YouTube does post it after processing the live video, go ahead and throw your comments in there. And tomorrow, what I'll do is I'm going to take a look at the comments that people post to this video tomorrow, and I'll start that off by answering a few questions there. All right. Thank you so much. I enjoyed it. Thanks so many of you from so many different states. I see Chicago there, and we'll see you next time. Y'all take care.